Good evening, Chair and committee members. My name is Krystal Gomez. I'm an immigration attorney with 15 years of experience representing immigrant families across our state, and I'm here to respectfully oppose the committee substitute for HB 232. Since I'm an immigration attorney, I'm going to focus this testimony on immigration law and how this bill conflicts and excludes countless immigrants who have lawful presence in the United States. They, through no fault of their own and due to the complexities of federal immigration law, either don't yet or may never qualify to apply for lawful permanent residence despite years or even decades of authorized residence in Texas. I have represented hundreds of these young Texans that would be harmed by this legislation. DACA recipients who've been vetted by the federal government, work legally, pay taxes, contribute to our communities, yet have no statutory pathway to permanent residence under current federal law. Family of military members, survivors of crime and domestic violence or persecution, with pending applications that might take more than 10 years for adjudication, all while they lawfully reside in Texas. All of these individuals can be lawfully present for extended periods, sometimes their entire lives, without qualifying for permanent residency. What deeply concerns me as an attorney is what Ms. Etter was testifying to a bit ago, is that in this committee substitute, since we hinge eligibility for in-state tuition on a pending application for permanent residence, and so many people are not qualified for that we're going to place these young 18-year-olds into a position where they apply for a benefit that they are not eligible for in order to qualify for in-state tuition and be able to afford college. And if that happens, they're in a very precarious position. Not only are they going to be out the thousands, sometimes upwards of $3,000, $4,000 in application fees that these permanent residence applications cost, but they're also putting themselves at risk of getting put into deportation proceedings, as Ms. Etter testified to under this new February memo that USCIS has put into place. So additionally, as you've heard tonight, immigration status isn't static. Today's Texas DREAM Act beneficiary will become tomorrow's legal permanent resident or U.S. citizen, able to work lawfully in the U.S. Several of my clients who were educated in Texas thanks to the DREAM Act have worked right here in this building as legislative staff, contributing to their talents, insights, and hard work to this state. They're now legal permanent residents, citizens, but some, as you've heard, are still stuck renewing their DACA every 2 years because the federal government has failed to fix our broken immigration system for decades. Texas can do better than this bill, and I urge you to reject Committee Substitute 232.
Thank you.